Hello, my name is Oliver Matthews at Anglia DNA Services. I look after business development. Anglia DNA Services is the UK's leading paternity testing company, and what we will do once you instruct us is we will contact your clients and we'll arrange DNA samples to be taken from either a GP or one of our own trained scientists who can visit your client in their home, your office, a prison or a detention centre, making the whole process quicker and easier for you. We take out all the legwork in arranging a DNA test. Then, once we receive the DNA samples in our laboratory, we can actually process the samples and deliver a report to you the same day. So, for example, if we receive the samples at 9 AM, we can actually deliver you a report by 5 o'clock by email the very same day. Visit our website at www.angliadna.co.uk, where you can now place your instruction online.
Hello and welcome to the latest legal update for the Solicitors Group TSG Legal TV family channel. My name's Godfrey Freeman from Moorcrofts in Liverpool, and today I will be discussing some recent developments in the field of family financial matters. These are all hot topics and I'm sure you'll be interested in them. First of all, can I touch on money laundering? This is a very important thing so far as family lawyers are concerned. Somehow we feel that husbands are putting money away, causing problems, hiding it and such like, and we as solicitors dealing with that client have to be very careful. As a result, the Law Society has just issued some new guidance. I won't go through it, but it is on the Law Society website, which I'm sure you'll know is at www.lawsociety, all lowercase, all one word, .org.uk, and it's very useful. There's also an article at page 32 of Family Law Week for December of last year. Looking at the Law Society and their website, they've also dealt very recently with guidance on social media for lawyers generally. This again can be got from their website, and I do recommend it to you as solicitors. Certainly when dealing with matrimonial clients, I always advise them at the initial instruction to come off all the websites and media channels, because they can inadvertently put stuff on there that can be used against them by the other side. Turning to mediation, this appears to be the government's panacea to cure all ailments in family law, both children and financial. There have been two recent press releases, first of all by Jonathan Jangoli, the Ministry of Justice in January, start of January, and then by Ken Clarke, the Minister, on the 23rd of January, where mediation is said to be the future for separating families. Unfortunately, there's no talk of other ADR processes, such as collaboration, or indeed what I'm just going to come to, which is arbitration. There are these other methods, and due weight should be given to those. So far as arbitration is concerned, this is a very new scheme introduced 12th of February this year by the Institute of Family Law Arbitrators, which is an offshoot from the Institute of Chartered Arbitrators. It's a combined effort by the arbitrators from the Chartered Institute, the Law Society, Resolution, and the FLBA. It deals with financial matters only and needs the agreement of both parties. However, it's hoped that this will take some of the bigger financial cases away from the courts. The parties will be free to choose, with the assistance of the arbitrator, and again they can choose the arbitrator, how the procedure should work, what should happen with costs, and generally how the matter should be dealt with. One point that one has to make is that there are some judicial queries over the enforcement of any determination, but I see no reason why any award made in arbitration should not be enforceable as a contract, even if it can't be dealt with under the Arbitration Act. There are various articles about this, and also, again, a website for the Institute of Chartered Arbitrators. Another matter which is a hot topic at the moment, and one where there's perhaps not so much doom and gloom for family lawyers, is the modernisation of family courts. This is an initiative led by Mr. Justice Ryder, and he's been asked, if not ordered, to report within 6 months. He's got a deadline of 31st July this year. Basically, he's looking for good practice directions, decent protocols, and a thing that I know Resolution have been pushing for more years than I care to remember, unified family courts. At the moment, we are seeing buildings that are able to cope with unified family courts, where the Ministry has been putting family proceedings courts, county court and high court in the same building, but not unifying in the full sense of the word. This is one of the things that Mr. Justice Ryder will be looking at, and I'm sure we can see some developments there. Legal aid, this is not modernisation. This is going back, as a legal aid lawyer, I feel able to say this, going back to the dark ages before the 1949 Act. In simple terms, so far as private children work and financial remedies work are concerned, it is vanishing. There is only going to be legal aid available in those cases where there is domestic abuse, and the government's definition of domestic abuse is very restrictive, despite having the bill rejected in some of these matters by the House of Lords. They're going ahead, they will not relent. There is this query over the definition of what is domestic abuse, and I understand that they're still going to continue with the proviso that even where there is domestic abuse, any injunction or criminal proceedings must have been within the previous 12 months. That would appear to most of us to be an unreasonable time limit. It's not sure when these changes will be implemented. There have been delays. The likely period is probably April of next year. However, some things have already been brought into force. One, as most of us will perhaps already know, is the reduction in family fees. There's not many areas these days where fees are reduced, but certainly this is one of them. The reduction of 10% and the reduction to additional enhancements have gone for all new cases after the 1st of April, and I'm sure that that will be something you will bear in mind. This is going to mean an increase in LIPs, or what now seem to be called SERPs. I always thought SERPs was the State Earning Related Pension Scheme, but apparently it means self-represented persons. I'm going to use LIPs because I find that easier to use. This, I think, is going to cause delays at courts, where the number of litigants in person is going to increase. It's going to mean more expense for the other party if they are paying privately, as they will be expected to do most of the legwork, so to speak, preparing bundles and such like. I know already that in my local court in Liverpool, judges are finding difficulty in financial matters where there is a litigant in person when it comes to consent orders that have been arrived at after FDRs. In one case, which I was told about only last week, there was a litigant in person. He didn't want his wife's solicitor to draft the order that they'd reached in the FDR proceedings. The judge, who was a deputy, was not prepared to allow the wife's solicitor to do it, said she would do it herself. Unfortunately, despite it being a clean break order, she didn't put the appropriate clause in. I'm told there was more red ink than black ink by the time it had been finished with. That caused extra work and extra cost. Is there any light at the end of the tunnel? Possibly. Advocacy for solicitors. This is an area in public law work where solicitors are getting paid a reasonable amount for the work they do, on a par with barristers. And in the financial side of things, I think it's pretty plain to most of us that solicitors are doing more of the work, certainly up to, if not including, final hearings. And this is something that is appreciated by clients, as they have the same person who's familiar with the case dealing with it, certainly up to the stage of the final hearing. Just a point at the end here on barristers, and my apologies to all barristers listening in to this, but I've seen recently efforts by the Bar Council to improve direct access to barristers. One of the problems in family matters has always been that barristers can't deal with clients' money, and that has caused problems in dealing with lump sums, transfer of property and such like. That, I am told, may change, and there is going to be direct competition of that sort. One of the officers of the Law Society in Chancery Lane has suggested this may be an appropriate time for fusion of the two sides of the profession, and I leave you with that thought. So, on behalf of me and the Solicitors Group, thank you for listening to this legal update. Keep an eye out for further updates from TSG Legal TV, and we look forward to seeing you again soon. Goodbye.